Is Marlene, are you ready?
Just a minute, yeah.
Oh, she needs a minute. Okay.
Previously.
Okay. Whoa. I'm fine. I fell out of my shoe. You're lucky I didn't fall on you.
Need new shoes.
No. I can't wear Cinderella's shoes, sorry.
Okay, I'm ready.
Call this meeting to order. Roll call, please.
Member Aaron Cook?
Here.
Member Bill Bruner? Member Donnie Bryant?
Present.
Member Mario Todd has previously excused himself. Mayor Carr?
Here.
Attorney Leslie Votaw?
Here.
And myself.
The board had previously met last night in an executive session and reviewed proposed findings of fact and conclusions of law. I'm going to go ahead and read those, and then we'll take a vote. First of all, there is a procedure of the proceedings. Number one, pursuant to Indiana Code Section 36834, on March 20th, 2013, the Board of Public Works and Safety, hereinafter the Board, after receiving and discussing evidence in an executive session, voted in a subsequent public works session to give notice of their intent to dismiss the officer Doug Taylor, hereinafter the officer, from the Lawrenceburg Police Department. I'm going to refer to them as LPD. The officer made a timely request on March 25th for a hearing on the charges and waived the 30-day time limit for the setting of the hearing. Thereafter, on March 27, 2013, the Board by Counsel Leslie L. Votaw, hereinafter Board's Counsel, gave the formal notice to the officer pursuant to Indiana Code Section 36834C, including the date of the first setting of the termination hearing on April 17, 2013 at 4:30 p.m. to be held in Lawrenceburg Common Council Chambers. Number 3, subsequently on April 9, 2013, the Board's Counsel gave notice to the officer and his attorney, Richard Butler, hereinafter Officer's Counsel, that the hearing needed to be rescheduled and set it for May 2, 2013 at 4:30 p.m. to be held in an executive session. In the meantime, the Chief, and that would be Chief Hunnefeld, hereinafter Chief, upon advice of the Board's Counsel, retained his own counsel, Jeremy Diltz, hereinafter Chief's Counsel, due to an inherent conflict of the Board's Counsel acting as, quote, judge and the, quote, prosecutor in the proceedings. 4, thereafter, the Officer's Counsel responded that he and his client could not agree to the May 2nd meeting and asked that it be set after June 3rd, 2013, when he returned from a vacation out of the country. The Board held a public work session on April 23rd, 2013, at which time the Board voted to proceed with the hearing on May 2nd, 2013. That was number 4. Number 5, on April 24, 2013, the officer filed a complaint for declaratory judgment for preliminary and permanent injunction in the Dearborn Circuit Court concerning the issues of alleged illegal executive sessions by the Board, having the requested hearing in an executive session, and whether or not there had been a disposition of the criminal matter upon which the charges rested. On April 26, 2013, the officer also filed a formal complaint in the Office of Public Access Counselor, alleging many of the same issues as in the injunction suit. Due to the filing of the lawsuit in Dearborn Circuit Court, the Public Access Counselor refused to issue an opinion pursuant to Indiana Code Section 514.410, subsection 6. The Officer's Counselor and the Board's Counsel ultimately agreed to dismiss the injunction complaint and move the hearing from May 2nd to June 6, 2013, which was a scheduled conflict with the Chief's Counsel and then it's set for June 19, 2003, which was also not acceptable as a witness for the chief was not available. Eventually, number 6, the hearing was set for July 11, 2013, to which all parties agreed and constituted the executive session portion of the hearing. The board's counsel had attempted since April to set a pre-hearing conference between the parties to address any stipulations or objections and to set some parameters to incorporate in a pre-hearing entry, but did not receive a response from the officers' counsel. Therefore, the only issues discussed at the July 11, 2013 hearing were the officers' various procedural objections. At the end of the hearing, the issue of voir dire of the board was addressed, and one of the members of the board recused himself, and with one member already absent, the parties agreed to continue the hearing and eventually set it for August 28, 2013. Number 7, the officers' counsel filed another complaint for an injunction on August 21, 2013, which was heard on August 26, 2013 by the Dearborn Circuit Court concerning the executive session issue and the disposition of the criminal charges issue. At the hearing, the parties stipulated to hold this termination hearing in a public session, and the court found that the filing of the deferred prosecution agreement entered into by the officer was indeed a disposition of his criminal charges under Indiana Code Section 36-834, subsection N. Number 8, at the August 28, 2013, the voir dire of the board was performed, and the chief finished his case in chief. However, when it was time for the officer to start his case in chief, the officer sought a continuance based on missing records that were subpoenaed from the clerk treasurer. The board conceded to continue it, and it was set to conclude on September 10, 2013. In the meantime, the officer again sought a continuance based on unavailability of one of his witnesses, but the board decided to proceed on September 10th and agreed to continue the hearing again if needed for the unavailable witness. Hence, the last session of the hearing was finally conducted on September 20, 2013. Procedural findings. Number 1, throughout the course of the proceedings, the officer, through counsel, objected to the existence of the termination proceedings for a variety of procedural grounds. 2, although the board finds that the procedural objections lodged by the officer were thoroughly addressed on the record during the hearings, it will provide this summary of some of its findings on those procedural matters. However, this summary is not intended to replace the holdings the board made during the hearing. Instead, they are only a guide to provide the general rationale regarding some of the procedural objections. 3, the officer objected to the termination proceedings on the ground that the members of the board are biased and prejudiced against him. The board denies that any of its members are biased or prejudiced against the officer. No evidence has been presented to demonstrate any animus or actual bias against the officer by any voting member of the board. 4, to the extent the allegations of the criminal activity levied against the various members of the board by the officer suggest the appearance of bias or prejudice by the members of the board observes that it is the body charged with holding this termination hearing by statute. As in the case of Jandura versus Town of Cherryville, 937 Northeast 2nd, 1814, it's an Indiana appellate case of 2010, the board is presumed to act properly and without bias or prejudice in the absence of a demonstration of actual bias. The officer's due process rights are not infringed upon in such circumstances. 5, the officer has also objected to these proceedings on the grounds that his deferral agreement did not constitute a final disposition of the criminal charges against him under Indiana Code Section 36-834N. As previously decided by the Dearborn Circuit Court, it is also the holding of the board that the entry of the deferred prosecution agreement does constitute a final disposition of the criminal charges against the officer. Therefore, it was appropriate to proceed under Indiana Code Section 36-834. 6, the officer has argued that the chief and the board have no ability to discipline the officer for the same matter twice, pursuant to the standing operating procedures, hereinafter SOPs, entered into evidence. The officer has also urged, without reference to any evidence, that the SOPs are unlawful and not binding. 7, the board finds that the SOPs were lawfully entered into and therefore control these proceedings. Even if there was some defect in the adoption of the SOPs by the board at the time they were purported to be adopted, Indiana Code Section 36-833, subsection G, permits the chief exclusive control of the police department, subject to the rules of the board. If the board did not properly adopt the SOPs, then those SOPs simply amount to rules promulgated by the chief in his capacity as having exclusive control of the police department. The undisputed testimony during the hearings has revealed that all members of the department, including the officer, were subject to, agreed to, and were bound by the SOPs. Number 8, the undisputed evidence in this case is that the officer received a verbal reprimand from the chief shortly after committing the offenses to which he admitted in his deferral agreement, and that the chief then referred the matter on to the prosecutor for additional investigation. There is no evidence that the verbal reprimand was intended to be the exclusive avenue of discipline. The mere fact that the officer subjectively believed that the verbal reprimand was the entirety of the discipline he was to receive is of no import. That belief was unfounded and it does not control these proceedings. 9. The officer also argued that the SOPs require that he be provided with a summary of the evidence to be used against him at this hearing. The board concludes that the officer's repeated and ongoing reliance on the SOPs to form the basis of various procedural objections, including the ones noted above, constitutes a waiver of any argument that the SOPs were not in effect and do not govern these proceedings. Further, and as noted on the record, the board finds no procedural irregularities with the summary of evidence provided to the officer in advance of the hearing dates. 10. The board sustained the officer's procedural objection to conducting the entirety of the termination proceedings in an executive session. The officer provided a compelling argument at the initial hearing date, based in part on the SOPs and the city ordinance, that the officer was entitled to a public hearing. As such, the entirety of the transcript of the initial portion of the hearing, which had not occurred in public session, was made public by agreement of the parties. The other 3 portions of the hearing were public sessions, including this one today. 11. As stated in the previous section, the officer also objected on at least 2 occasions to completing the hearing, either because witnesses or exhibits were unavailable. In the interest of fairness and to allow the officer to provide a full and complete defense, the board suspended the hearing on those occasions and rescheduled them to accommodate the officer. The chief was also afforded continuances in this matter. 12. 2 pre-hearing entries were entered into the record in this matter and marked as joint exhibits, containing the procedure of the hearing, including the preparation of these findings of fact and conclusions of law. Findings of fact. The board, in reliance of the evidentiary materials entered into evidence C1 through C4 for the chief, 01 through 01 through 050 for the officer, and all joint stipulated exhibits, as well as the testimony of the witnesses heard by the board, enters these findings. 1. At all times relevant to this matter, the officer was employed by the city of Lawrenceburg. 2. In April of 2011, the officer, while campaigning for city council, attended a campaign function while on duty and in uniform for the LPD. 3. After the event had concluded, it was brought to the officer's attention and the attention of the administration of the LPD that the officer had attended a city council campaign function while on duty and in uniform for the LPD. The officer admitted at that time to having engaged in those activities. 4. The officer further turned in time spent as time on duty and was paid for the time that he attended the campaign function. 5. The officer was reprimanded by the LPD administration, and the matter was referred to the prosecutor for additional investigation. 6. The Dearborn County prosecutor, Aaron Negengard, has appointed a special prosecutor, Daniel Ziegler, to investigate the claims against the officer. 7. After investigation, the officer was charged and prosecuted in October 2011. 8. After the prosecution against the officer was initiated, the officer was placed on paid administrative leave from his duties as a Lawrenceburg police officer. Subsequently, when the new administration took office in January 2012, he did perform work for the city of Lawrenceburg in other capacities, including as a police clerk. 9. On March 13, 2013, the officer entered into a deferred prosecution agreement in which he admitted to knowingly or intentionally committing the crime of conversion, being paid while attending a campaign function, and to recklessly soliciting votes or performing a campaign function while in his police uniform. While the intentions of the parties to said agreement was that he admitted to the amended counts, which were misdemeanors, the agreement does state that he admitted to the probable cause affidavit based on 2D felonies. 10. The page 22 of the SOPs in the section entitled Rules and Regulations provides as follows. Any employee found guilty by hearing before the Board of Works of Conduct be unbecoming an officer, insubordination, neglect of duty, or violation of the law will be subject to suspension and or dismissal. 11. Pertinent portions of the SOPs on pages 31 and 32 in the section entitled Disciplinary Measures provides that the term misconduct and cause to suspend, demote, or discharge shall include the following among others: any act of malfeasance, conduct unbecoming an officer while on or off duty, and violation of any rule or regulation. 12. Immediately prior to the execution of the deferred prosecution agreement, Special Prosecutor Ziegler contacted Prosecutor Negengard and informed him of the terms of the deferred prosecution agreement. Aside from the initial contact with Mr. Ziegler to request Mr. Ziegler's participation, There is no evidence of any other communication between Mr. Ziegler and Prosecutor Negengard during the pendency of criminal charges against the officer. 13. One day after executing the deferred prosecution agreement on March 14, 2013, the officer disseminated a letter purporting to detail various felonies and misdemeanors allegedly committed by all members of the board, various City of Lawrenceburg officials, and the mayor, among others. The letter was disseminated to Prosecutor Negengard, the Chief, the Superintendent of the Indiana State Police, the Indiana Attorney General, the United States Attorney's Office, the Federal Bureau of Investigation, 8 television news stations, 4 based in Indianapolis, Indiana, and 4 based in Cincinnati, Ohio, the Cincinnati Enquirer, 3 Indiana newspapers, and 1 local radio station. The letter requested an investigation into those purported crimes. 14. There is and has been an ongoing investigation into various matters involving the City of Lawrenceburg by the State Police and/or the Federal Bureau of Investigation, including for a period of time preceding the dissemination of the officer's March 14th letter. The undisputed evidence is that the investigation remains ongoing. 15. None of the individuals identified in the officer's March 14th letter have been arrested, indicted, or prosecuted. There is no evidence or indication at this point that any of those individuals will be arrested, indicted, or prosecuted. 16. Prosecutor Negengard testified that because the officer's allegations were made public during the pendency of an ongoing investigation by other law enforcement officials, he does not have a favorable opinion of the officer. The undisputed testimony from Prosecutor Negengard is that he believes that the officer's allegations may have impaired the investigation by bringing undue publicity to the matter. There is no evidence that Prosecutor Negengard had an unfavorable opinion of the officer prior to the dissemination of the March 14, 2013 letter. 17. Prosecutor Negengard testified that he is unwilling to receive information from any police officer who has admitted to or been convicted of a crime of dishonesty because it makes the prosecution of suspects much more difficult. Therefore, he informed the chief that he, Prosecutor Negengard, could not accept information from the officer due to the officer's judicial admission to the crime of conversion, which is a crime of dishonesty. The board credits Prosecutor Negengard's testimony in that regard. The officer is the only officer from whom the prosecutors have refused to accept prosecution information. 18. The board finds Prosecutor Negengard's testimony credible. 19. The officer testified that many officers with the LPD conduct personal business while on duty in uniform. The board finds this testimony to be credible. 20. The officer also testified and provided evidence that there were at least 2 other Lawrenceburg Police Department officers who have been convicted of or admitted to certain criminal activity and nevertheless remained employed or began employment with the LPD. The board finds this testimony credible. 21. The testimony and the evidence demonstrate that the other officers identified by the officer were convicted of or admitted to criminal activity that took place while the officers were off duty, not in uniform, and not being paid by the LPD. In addition, none of the other officers' crimes involved dishonesty. 22. The chief testified that it is important that a police officer be able to provide information to the prosecutor to assist in the prosecution of crime. The officer testified to his belief that it was not important that an officer be able to provide information to the prosecutor as part of his job duties. The board credits the testimony of the chief and does not credit the testimony of the officer as to the importance of a police officer's ability to provide information to the prosecutor's office for the purpose of prosecuting suspects. 23. Former Lawrenceburg Police Department officer William Hoffman testified that he was precluded from providing information to the prosecutor by the chief during the last few years of his 42-year tenure at the department. He also testified in regard to his case reports and affidavits, which were prepared for his signature, that he either did not tender them for prosecution, no prosecution came of them, even if they had been tendered by him, or the cases were handled by a different officer so as to effectuate prosecution. Given Mr. Hoffman's equivocal testimony as to his recollection of preparation, signature, and tender of those documents, the board gives minimal weight to Mr. Hoffman's testimony. 24. The board recognizes that there were witnesses who testified and exhibits admitted into evidence that were not referenced in these findings. The absence of reference does not mean that the testimony evidence was not considered. Rather, the board did not find those exhibits and testimony to be helpful in assisting the resolution of the issues at stake. 25. A conclusion of law that state a finding of fact is hereby adopted as a finding of fact. The conclusions of law. 1. This matter is properly before the board, and this board has the lawful authority and statutory duty to resolve the matters of law and fact raised by the chief's charges against the officer. 2, because the City of Lawrenceburg is a third-class city, the procedure to be utilized in the consideration of this matter by the Board is set out in Indiana Code Section 36834. This procedure has in all respects been correctly applied in the consideration of this matter. The officer and the chief were each given a hearing in this matter in accord with their constitutional and statutory due process of law. 3, in this matter, the chief has the burden of proof by the preponderance of the credible evidence that the officer has committed one or more of the offenses which constitute a basis for discipline in Indiana Code Section 36834B. 4, based on the foregoing evidence, the Board concludes that the chief has proven by a preponderance of the credible evidence that the officer's conduct as described in finding of fact 2, 3, 4, and 9 is an offense prescribed in the SOPs recited in finding of fact 10, is in violation of the SOPs recited in finding of fact 11, constitutes a violation of rules as that term is used in Indiana Code Section 36834B2B, and constitutes conduct unbecoming an officer as that term is used in Indiana Code Section 36834B2H. 5, although the officer is correct that other officers, including one prior to being hired and one prior to the adoption of the current SOPs, have violated the law, the conduct of the officer is more serious as it relates to the functioning of the LPD. The admission of a crime of dishonesty and refusal of Prosecutor Negengard to accept prosecution information from the officer impairs the functioning of the police department. Further, committing a crime of dishonesty while on duty and in uniform as a police officer undermines the faith and credibility of the public in dealing with members of the LPD generally and the officer specifically. 6, the officer has suggested that the instant proceedings were commenced only after the dissemination of his March 14 letter. The Board finds that there is no causal connection between the March 14th letter and the initiation of termination proceedings against Officer Taylor. The Board finds that the instant proceedings are causally related to the resolution or disposition of judicial proceedings against the officer, which occurred only one day prior to the dissemination of the March 14 letter. Specifically, pursuant to Indiana Code Section 36834N, the officer was subject to criminal charges prior to the execution of the deferred prosecution agreement, such that disciplinary proceedings could not commence until after the execution of that agreement. The Board finds that until the officer admitted the elements of his criminal activity in the context of a judicial proceeding, any prior admission by that officer and by the officer was entitled to less weight. The manner in which the officer sought during the course of this hearing to minimize the significance of his criminal activity bolsters the Board's conclusion on that point. Number 7, a finding of fact that states a conclusion of law is hereby adopted as a conclusion of law.
Entertain a motion, the findings of facts and conclusion of law. Motion to accept them.
I'm so moved.
Second.
Second.
All in favor?
Aye.
Got roll call, please.
Aaron,
No.
Bill,
Yes.
Donnie,
Yes.
We're going to take a 5-minute recess.
oh, that's the mayor car. Yeah. Yeah. Donnie Ryan. Accepting those things that she wrote. Right here, I wasn't sure how it all got to this point. The next to Leslie is Bill. He's right there, yeah. Aaron Cook is on the purple shirts. I don't know who anybody is. She knows her. No, I'm here. I printed up this photo. Okay. Yeah. No, I'm here. Oh, okay. What treasure? Yeah. Look at me.
Aaron.
Oh, did she?
Oh, I know.
Yeah. I can get it. Say something.
I ate yours.
Oh, okay. Tell her I said that. You probably needed it, you know, because I don't need it, so you can just
No, because
have
you
it.
never asked my opinion on any other storage unit for instance. I want no comment on this one either. Well, I've seen plenty on Channel 12 without considering the past few days.
Now's your opportunity to do it.
No, if I can't get opportunity at all, then I'm not going to delay. When you, yeah.
They said the chief told the truth. The chief told the truth. Is that what I I can't believe I heard that. Let me clean my ears out.
Okay. Okay, thank you. I haven't seen anything.
That's not a doctor. That's a chief. If he spoils me, I wouldn't still be doing this. I could not stand to see him. You got them in your truck? I'll take one. It'll keep me working a long time. You never been there?
Starts but won't stop. Oh.
I think I want my driveway. I mean, my concrete. I want Oh, is that Yeah, I think so. She's got her it's called
I can't believe it's fun like turn this thing off. I come in here now and run.
Yeah, I know. It's good, but it's a better, better spot. But almost every I think even recess, I just got here. Yeah. Gotta make sure the goes over. The next week is you get the first. It'll be the first farmer's fair, right? When is the farmer's fair? I think it's next weekend. Should be.
That means like winter's coming. Yeah.
Rain and
Yes.
cold.
You got names? Oh, are you, is that where you're from?
So, okay, well, we'll make it close about that.
Oh, that's pretty, I like it. Like, I never saw that thing.
You look like one with all that gray hair.
That's not gray, that's silver.
Oh.
Gray's old, silver's past in sex.
I heard that.
How much longer?
Somebody else told me that.
How long does she have left?
21st of October.
Yeah.
Emily, my daughter, she's doing 7.
Before that, I had a child at the age of 8 in my home. I love baby. I'm excited to look at it.
Yeah. It's easier when you can play with them and give them back, too.
And this house is not as big as the one she's talking about.
Yeah. Yeah.
How can you even think about having one that's 6 feet long?
Yeah.
Well, you're still.
That'll be fun.
You know, I don't know if she is or not.
You got anything ready yet?
Yeah. When I don't have gel in it, it's real gray. Gel makes it look darker.
Wasn't the only one. Yeah. I was the one told her if I'd be sure to turn them off.
There's no taken out. But I don't remember. I remember the nauseousness. The people that told me nauseous, like, it's unfair. Can't you turn it all the way down? Oh, good.
I forgot to turn it off when it comes in.
Fred, take it.
At least there wasn't very much.
Forget it. I bought one time. I bought a ticket with Dave Dennis. One time I bought one at a time. I said, okay. 5 of them was split. Well, didn't want it. So then he bought it. Didn't have to. Okay. Because I kept saying, I'm the one that never buys them already. So I bought one and I'll win. I'm still working. Whenever they feel like coming back.
Yeah. Yeah.
What do they pay?
Yeah. You know what the community center is? Okay. You have to go down Walnut Street, go down at the end of the condos or townhouses. The stage is in front of the community center. And there's an area down in there. Yeah. 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 And then Friday night's country, Saturday night's rock.
That's okay.
I should have brought those things. I gotta go.
No, I'm right next to the
The chamber should have little cards.
I'm sure they do. I just did. I've been, what do they do? I've been working on it.
Well, if you think about, try the chamber first, if not, I'll come.
Because I'm right next to them.
Yeah, okay.
I'll walk over.
Okay, but they should have them too, and it tells you the evenings and what's on Thursday, what's on Friday, what's on Saturday. Yeah, it starts at 9, 5 o'clock.
Oh, I didn't know that.
Oh, hi, sir. Me and
I've been here, but Mom never made me do it. So I haven't done it yet.
Man, I've been on there like,
Nothing much goes on Thursday.
I'm sorry.
What's another set? What's another set?
I don't run.
Yeah.
Who you are, ma'am?
I'm just here to support Doug.
I see. Okay. Thank you.
I don't know the difference, but I've heard of last Saturday I heard of probably like 10 people.
We need to go on it.
Oh, those big slides are fun.
Yeah.
I think it's a little too high for me. I'm a little too old.
I like the big, when I'm with my grandkids, to holiday. Water slides now. Oh, those are fun.
Are they?
Yeah. Taking so long.
It's probably down in Southern,
Yeah.
that's Holiday World, yeah.
Yeah.
5 minutes here, I've been to the park itself. I know.
It's real.
I've been, and I used to, a number of years ago, I worked with a girl that her and her husband went down there once or twice here in Kansas. I
went there, it was 2 years ago with my daughter and grandkids. Well, I can't get enough of my I'm done with that. But I rented like one of the
Like
mobile home type.
Yeah.
And I rented one of those. And it was nice. And you go right from we rent that. Kids got tired. It was real. It was nice.
Probably true.
No, this was the park itself had their own thing, right? And they also have a tent. Oh, really? Okay. And they love the camp. It's like, okay, I did my share. Yeah. Like when the girls were like,
Well, I don't know. Yeah, they post up.
Call us back in session. How would the board like to proceed?
I make a motion to terminate.
I have a motion to hear a second.
Second.
All in favor?
Aye.
All against?
Aye.
Roll call, please.
Aaron,
No.
Bill,
Yes.
Donnie.
Yes.
Yes, sir.
Yeah. I do need to advise the officer at this point, an appeal under this 36834 must be taken by file in court within 30 days after the date the decision is rendered. That would be today. A verified complaint stating in a concise manner the general nature of the charges against the member, decision of the safety board, and a demand for relief asserted by the member. A bond must also be filed that guarantees the appeal will be prosecuted to a final determination, and that the plaintiff will pay all costs adjudged against the plaintiff. One of the things that have to be done too is that this board will have to, within 10 days of service of summons, the safety board will have to file in court a complete transcript of all papers, entries, and other parts of the record relating to the particular case, and we will definitely do that upon any kind of summons.
Entertain's motion for adjournment.
So moved.
Second.
Second.
All in favor?
Aye.